AJ, okay, so guys, what is y'all's appetite for a little bit of innocent copyright infringement?
Low.
What are you talking about?
So, okay, do you guys know that Taylor Swift song, Baker's Gonna Bake, Haters Gonna Hate? Do you guys know that song?
Yes.
So, I just think that that's like a very appropriate song for this episode.
Wouldn't that be fair use?
Oh, I see, because the Republican tax bill is written by such haters.
Well, I was going to say that because...
And Cakeshop.
The Cakeshop, Baker's Gonna Bake.
Oh,
then,
yes. Do
you see where I'm going with this thing?
Yeah. The taxers, the tax bill isn't very good, is what you're getting at. But you just have to shake it off.
Well, that's another place where I could be going. Do you see what I'm saying? That's why I think our intro music today, when AJ's done editing this episode, I think our intro music should be Baker's Gonna Bake, Haters Gonna Hate, Shake It Off, It just seems like a really apropos song for these purposes.
Oh, wait, Ruchit, I understand now. Sorry, I thought about it some more, and what I understand now is that the reason why you would use that song is because Susan Collins got played.
Oh, shit.
What are we talking about this week? We're doing the conference committee for the tax bill. We're doing the Cakeshop case. Which one do you want to do first?
I mean, let's hit the let's hit the conference committee. I think let's hit the conference committee.
Okay, so the tax bill, the Tax Cuts and Jobs Act, the House passed a version, the Senate passed a version. The House and Senate version are not the same, and so I think that's it. We're done, right?
Yeah. So no, we're definitely not done at that point. So this situation, folks, happens all the time, right? It happens in the state level, the federal level, right? Where the House passes one version of a bill, the Senate passes another version of the bill, right? And what the conference committee does is it drafts a compromise bill that they think both houses will accept, right? And so, you can't have the bill that goes to the president for signature or for veto has to be, that specific bill has to have been passed by the Senate and the House. So you can't have these differing bills, because then it would be like, which bill goes to the president of the United States, right? So typically what happens here, and this is just background, right? You have a House bill and a Senate. You have a House bill. The House bill goes over to the Senate. The Senate modifies the hell out of that bill, which is more or less happened as it relates to this specific tax bill. Then that bill goes back to the House, because the version of the bill that the Senate approved has not been approved by the House. So the House then takes that bill, and they've got a couple of choices, right? Or they've got three choices, I guess. The first is to say, F you, Senate, we don't like this bill, we're not approving this bill, and we're done here. Okay, so that didn't happen in this case. The second thing they can do is they can say, listen, the Senate is filled with wiser human beings. They just have more experience. They're elected to 6 years, while us, we're only elected to 2. They represent the cooled passions of the wise, whereas we merely, we are the passions of the people. And so, we're just going to accept the Senate version as is, and we're going to pass this bill. Now, as of right now, that has not happened and does not look like it's going to happen. I think that still could happen. The third option, which is what has actually happened in this situation, which is the House requests that the Senate go to a conference committee, and then the House and the Senate they appoint conferees. So these are House members, so U.S. representatives, and then senators, U.S. senators. And then they hash out a bill, which ends up being called the conference report, it's not a report really, it's just a bill. And then that report, or that bill rather, goes back to both the House and the Senate, and they both have to approve that bill before it can go to the president. Did I do a decent job there?
Yeah.
So that's kind of what happens. And all of this happens kind of, for the most part, behind closed doors. I believe that the House does have a rule where they have to have at least one public hearing. I don't believe that the Senate has a rule like that. So, that's sort of what, from a procedural perspective, happens. And, typically what happens is that the differences are sort of negotiated between the two by the conference committee, and they write a bill that they think both houses at that point can sort of can agree on. And then it's up to the House and up to the Senate to sort of say, do we agree with this or do we not?
Who are the conferees for the tax bill?
Dude, there's so many conferees. There's I think there's 29 conferees on the. Hold on a sec. Let me pull that up real quick.
Tom, are you a conferee?
I'm not.
Oh,
so so here are your conferees on the Senate side. On the Senate side, you have Orrin Hatch, who's the head of the Senate Finance Committee. You have Mike Enzi from Wyoming, who's the chairman of the Senate Budget Committee. And then you have Lisa Murkowski, who is the chair of the Senate Energy and Natural Resources Committee. She's from Alaska. And they got – so this is a little bit of news, or not news really. It's just something that's been pretty well reported, is that the way that the Republicans got Lisa Murkowski on board is they used – in this bill they have a provision that allows drilling in the Arctic National Wildlife Refuge, which I am against. Then there are a few other conferees. McConnell also named John Cornyn, John Thune, Rob Portman, Tim Scott, and Pat Toomey.
I found the list of the Senate Democratic conferees.
Who are they, AJ?
Ron Wyden of Oregon, one of my favorite senators. Nice guy.
I like him a lot too.
Bernie Sanders, Patty Murray.
Are you about to say, I thought with Bernie Sanders you were going to say nice guy.
Yeah. Bernie Sanders has a lot that recommends him. Like, for example, having a lot of good ideas about public policy. Patty Murray, Maria Cantwell, Debbie Stabenow, Bob Menendez, and Tom Carper. I'm actually surprised that Bob Menendez is in the conferees because he's had so much controversy recently. The other thing is that I'm really surprised not to see Susan Collins on the list of conferees.
I think they could only put Susan Collins or, Lisa Murkowski, and I guess they just put Lisa Murkowski.
Why can they only have one but not both?
Well, I mean, they could have both, I suppose. I'm just saying that they ended up not. Probably because they needed to put other sort of Republicans on there. Because if they've got Lisa Murkowski, that's sort of your one token moderate, in air quotes, Republican. How many moderate Republicans can you put on this committee?
So I think something that we should talk about this episode is the real chance that whatever comes out of the okay. So first of all, the two things I think we should talk about are, one, why do we absolutely need a conference committee? What is the risk that the House will just vote out the Senate bill? And I think the second thing to talk about is what is the risk that the Senate will not be able to approve whatever comes out of conference?
I think the third thing we should talk about a little bit, at least, is some of the differences between the House and the Senate bill.
Yeah, that's a good point. Okay, so first, why do we absolutely need a conference? There are a lot of mistakes in both the House and the Senate bill, and neither bill, as passed the original House, I think has a realistic shot of actually being sent for the president's signature. Just like a couple examples. So first of all, the House bill isn't eligible for reconciliation because it has some terms in it that didn't survive the bird bath. The bird bath is when the parliamentarian tells you if there are terms that are not eligible for reconciliation. Bills that are ineligible for reconciliation are subject to the filibuster, and the Senate GOP does not have enough votes to overcome a filibuster. So there is no risk that the Senate will just be able to vote out the House bill. Meanwhile, the Senate bill is riddled with errors. I think the biggest one is that there were some adjustments to corporate taxes that Republicans made in the wee hours before voting out the bill, and that the adjustments to the alternative minimum tax were intended to raise about $40 billion, and they accidentally raised about $300 billion. And so I don't think the Senate would like the Senate bill to become law. And so there is no risk that either house can just vote out the other house's bill to avoid having a conference. And so we definitely need to have a conference report.
Yeah, and let me make a comment on that tax provision, right? So one of the things that the Senate bill did in the wee hours of the night, as AJ described, is they either accidentally, or I don't know exactly what their intention was here, but what they did do is they reinstated the corporate alternative minimum tax. So what the alternative minimum tax does is it says that, no matter how many deductions you have, more or less you have to pay this minimum tax rate. So they instated a corporate alternative minimum tax of 20%. So why does that matter? The reason it matters is because Republicans want to reduce the corporate tax rate to 20%. Now, they want to reduce it to 20%, but if you're a corporation, there are still lots and lots of loopholes in the tax code for you to take advantage of, right? And one of them being the research and development tax credit, for example. So 20% was, without an AMT, without an alternative minimum tax, is the effective maximum corporate tax rate that the Republicans would like, right? Now, if you have an alternative minimum tax that's equivalent to the maximum tax rate, then what you've effectively said is that every business will pay a 20% minimum tax rate, no matter how many other deductions they would otherwise be eligible for. So it actually eliminates all loopholes at that point if they were actually to keep this, because then it says everybody pays 20% if you're a corporation, not the most you will possibly pay is 20%. And which, remember, virtually nobody is actually going to pay 20%, just as virtually nobody was actually paying, or is actually paying today the 35%, which is the current maximum corporate tax rate.
So the short story here is that they actually intended to enact a bunch of deductions on corporate taxes, and the alternative minimum tax was structured in such a way in the Senate bill that it eliminates the value of those new deductions they created, because those deductions would bring corporate tax liabilities below the threshold where the AMT would kick in and negate those benefits. Is that like a good short synopsis?
Yeah, I mean, I think your synopsis is more detailed than mine. Good job, AJ.
Okay, so that is why we have decided that we are definitely going to have to do the conference process. We can't just have one house vote out the other house's bill. So, but by contrast, during the healthcare situation, there were some senators who had said, "Oh, we are voting to keep the process going, but we really hope the House doesn't vote out whatever we vote out." And Paul Ryan came back and said, "We're going to vote out whatever the Senate votes out," and that caused some senators, in the end, not to vote for the Republican healthcare plan. So this is not that situation. This is a situation where we're going to have some sort of conference committee, and that means that whatever comes out of the conference committee has to go back to a vote in both houses, right? The House and the Senate are going to have to vote again on these tax cuts. And so, what are the odds that whatever comes out of the conference committee actually can pass both houses?
I think they're pretty strong, right? Because I think they desperately want to pass a tax bill. I think actually, if this bill dies, the ways that I would see it dying are, one, they can't keep themselves within the $1.5 billion of deficit increase that under budget rules. Trillion, sorry. Good point, AJ. $1.5 trillion of increased deficit that under budget rules they have to stay under, because there's just too many things that they want that cost too much money, right? It's just hard to come up with. It's hard to come up with the difference, right? So, for example, the SALT deduction, right? So the state and local income tax deduction, removing that or modifying that is expected to save up to $1 billion, right? So that's going to represent $1 billion of tax increases on families that used to take. Now, that's not net, because those families will see some offset tax cuts. But just removing that provision alone raises $1 billion for you. So if for some reason, you have to change what you've done there, and you don't get to raise $1 billion anymore, that's a lot of new money that you have to come up with to stay within your bogeys. So I wouldn't be surprised if the conference committee produces a report, the bill gets scored, and they've busted the 1.5 billion. Trillion. Thanks.
I think a lot of the public have this problem where once numbers get big enough, their eyes sort of glaze over. I don't think that's what's happening to Ruchit, but I mean, for a lot of people, sort of the scales, the scales that the.
No, agreed. Yeah, I'm just stating it mistakenly, but I agree.
Yeah, the scales that like the public are dealing with, like once you start talking about the billions of dollars, sort of the distinction between say $100 billion and $1 trillion is sort of very difficult to conceptualize. It's the same way that it's like really difficult to conceptualize the distance between say the Earth and Jupiter. But like to be clear, the Senate bill before dynamic scoring would increase the deficit by about $1.4 trillion, and there are some sort of arcane rules about why. They need to keep the whatever comes out of the conference committee needs to have sort of a similar impact on the deficit over a 10-year window.
Yeah, and I think honestly, like I think the budget busting effects of this will be a lot larger, right? So let me sort of illustrate by example. And this is just my belief, right? This is certainly the CBO. And probably the Joint Committee on Taxation, too, does not agree with me. But no, they don't. They don't, because, I mean, they made a prediction that's different, right? So one of the predictions that I believe the Joint Committee on Taxation made is that if you repeal the Obamacare mandate. Now, so to be clear, they're not technically repealing the Obamacare mandate. What they are doing is they're removing the penalty for not having health insurance, right? So let's just, for sake of, just so that there's no argument on this, let's just say they're repealing the Obamacare mandate, right? So one of the things that the Joint Committee on Taxation says is that if you do that, there will be 13 million people that are no longer have health insurance. Now, the fact that the government, through some way or form, whether it's through subsidies or through Medicaid or through something else, no longer has to pay for health care for those 13 million people, whether it's through a subsidy or through Medicaid, as I said, is supposed to raise $300 billion. So if it turns out that people actually just keep their health care anyway because they're like, hey, I still want to be enrolled in Medicaid. I don't care whether I'm forced to be on Medicaid or not. I'm taking Medicaid. It's health insurance that's virtually free. Or they say, listen, I'm going to continue purchasing health insurance because I'm getting a subsidy and it's affordable, or whatever the case may be, then that $300 billion of revenue that they're counting on, to stay below $1.5 billion, may not actually materialize. So that's a situation where I think the policy outcome would be good, which is that, people have health insurance, but the fiscal outcome would not be that there's an extra $300 billion to play with.
Well, I mean, so Tom, what do you think is going to happen? Do you think they actually will be able to pass the conference version of the tax cut bill?
I mean, almost certainly they will, won't they? These people aren't going into committee blind as to what their members will and will not vote for, right? Like, that when they make these changes or when they make these agreements in conference, they're going to do it with the votes in hand. They're not going to do it blindly.
Yeah, you would think that that's what they would do, and that's why I think they're going to end up with not enough money, or that could happen. I'm not saying it's going to happen. I still think it's like an 80+% chance that this bill ends up becoming law, or some version of this bill, and that they do agree. But I think that they have to come up with money on state and local taxes, right? There's even smaller things where they have to come up with money where there are probably some House members and maybe even some senators that are like, hey, we should not be taxing, the income of grad students that is just them getting free tuition, right? Like grad students are poor enough. Maybe we shouldn't be taxing these people, extra. So there's items like that generate some revenue for this tax bill that people may just not get on board with. So, I'm hopeful. I'm hopeful that it doesn't become law because I think it's a bad bill. But
so I have a different view from y'all. I actually think it is a lot less likely than 80% that whatever comes out of conference is able to pass both houses.
Okay, what's your thinking?
So there are certain provisions in the House and the Senate bill that that each of the other chambers have said are sort of non-starters for them. They're just unacceptable. So for example, the Senate bill doesn't totally repeal the estate tax. It just, massively increases the exemption to the estate tax. the estate tax is only applies to about 0.2% of households, and it basically says, if when you die your estate is above a certain size, and by above a certain size we mean something like, presently it's around 5 or 6 million. Under the Senate bill it would be 11 million. Then the value of the estate in excess of that is taxed at about a 40% rate. So the number of households that have estates over $5 million is vanishingly small. And even among the households that have more than $5 million of assets, it's actually not that difficult to alienate those assets before you die, so that your estate is less than $5 million. Okay, so right, so there are a whole bunch of House members who have said that eliminating the estate tax is a deal breaker for them. Right, that the Senate bill, which maintains the estate tax, will not pass the House. Right. And so, maybe they're posturing, maybe they're not. I think that there are some other things like the corporate tax rate. Donald Trump has said that, it could go as high as 22%. I think the House has said that it can't go any higher than 20%. Presently it's like 35%, right?
Yeah, I think that's an area where they'll probably just go up, right? They're not going to sink this entire thing over, in my opinion, over whether the corporate tax rate is 20% or 22%. I think the type of posturing where, that's an area where if they really need to come up with like $20 or $30 billion, or I don't know how much the difference is between 20 and 22%, but I think they're going to come up with that money. I mean, that's a place where they can go.
So I think the area where votes are really scarce is in the Senate, right? So Bob Corker voted against the bill in the Senate. It passed 51 to 49, right? Republicans have 52 members, and let's say Bob Corker is out. Let's say Bob Corker is not a gettable vote, right? So they can afford to lose 2 more senators. If they lose 1 more senator, then the vote's 50-50, and Mike Pence will break the tie. But if Republicans lose 2 more votes, then it fails 49 to 51. So who are the other votes that are on the fence? Susan Collins says that she asked for a bunch of promises that she got out of Mitch McConnell before she was able to vote for the bill, and she has been a proponent of certain reforms to the ACA. There's Lamar Alexander and Patty Murray have a bill, and Susan Collins also has a bill that she supported, and they would make sort of some small incremental and positive changes to the ACA. These are actually like good bills that I think folks ought to support. And she said, well, if we're going to repeal the individual mandate, then I need these other stabilizers to help fix up the ACA. And Susan Collins says that Mitch McConnell promised her that they would pass Alexander Murray and a few other things. And, Donald Trump has since said, I don't really care. And Paul Ryan has said, I was never part of that deal. The other big thing that Susan Collins wants is a pay-go waiver. So I think we talked about a couple episodes previously that there's a law called the pay-go. It was enacted in 2010. And the idea of pay-go is that if bills have above a certain size impact on the deficit, then the Office of Management and Budget is required to immediately sequester certain entitlement programs. And so what would happen is that the Office of Management and Budget would be required to cut, $25 billion from Medicaid and about $100 billion from other safety net programs. And Susan Collins says, well, I got promised that there would be a pay-go waiver, and that's why I'm voting for the bill. So if these things don't happen, right? If it becomes clear that Susan Collins is not getting her pay-go waiver, or she's not getting Alexander Murray, or whatever else Mitch McConnell promised her, I think Republicans could really lose her vote. Susan Collins, right? And so that gets you down to 50 votes. And so what's the other senator you lose? Well, you could be losing Luther Strange.
Yeah. I think there's. Yeah, you could lose Luther Strange, and honestly, I think if Luther Strange, or rather, if Doug Jones wins the Senate race, I think it becomes very difficult as a practical matter for a lot of Republicans to. I mean, I think they just suddenly become a lot more uneasy. Maybe it impacts the tax bill, maybe it doesn't, but you could lose. I think you could lose that, and you still could lose Jeff Flake.
Yeah. So just to be clear for everyone, Luther Strange is the incumbent senator from Alabama, and there's an election on Tuesday, December 12th to replace Luther Strange, and the winner will either be Republican Roy Moore, an accused pedophile and child molester. On the other hand, you've got Doug Jones, who prosecuted
the Klan.
who prosecuted the Klan members who bombed the Alabama church in the 60s.
And that killed children, lots of children.
Yeah. So, Doug Jones, I think, is fair to say, would be a reliable vote against the tax cuts, and Roy Moore may or may not be a reliable vote for the tax cuts. There's a real chance that Republicans are able to finish the conference process and get the bill back on the floor while Luther Strange is still an incumbent, but there's a real chance that they don't. I think Ruchit's right that there are other senators that are gettable. I think Jeff Flake is gettable.
Yeah, this would be. We're just totally speculating here, but that would be it'll be interesting to see if they call Susan Collins' bluff, right? I hope they try. Honestly, I hope they try. Can I tell you guys, sort of slightly, not really switching the topic, but can I tell you guys some of the more interesting things that I found upon reading the Joint Committee on Taxation's report on these two bills?
Yeah, do it.
Okay, so this is interesting. The Senate bill extends combat zone benefits to troops serving in the Sinai Peninsula of Egypt.
Is that good policy? I actually don't know anything about this.
Well, isn't that kind of odd? So the Sinai Peninsula of Egypt is the area where the Gaza Strip is, right? I didn't see, or I don't know if we actually have troops in the Sinai Peninsula of Egypt, but I don't know why we would have that many troops in the Sinai Peninsula of Egypt. And so when I read this, I was like, is there someone that thinks we might have a war in the Sinai Peninsula? And as a result is just, wanting to make sure that combat zone benefits are available to any troops that might serve in the Sinai Peninsula? It's just kind of an odd provision, I thought.
What else? What else is weird about either the House or the Senate bill?
Okay, so there is the Senate bill repeals the income and FICA tax inclusions for employer-provided bicycle commuter fringe benefits. So if you get bicycle commuter fringe benefits, that's going away in the Senate bill. Then it also disallows deductions for expenses associated with entertainment meals, including meals in connection with recreational, social, or similar activities, primarily for benefit of rank-and-file employees. It's kind of a weird thing to take out, right? It's good, right? Here's another one. Repeals deduction for expenses associated with providing employees with qualified transportation and parking benefits. So, your employer is no longer, if they give you that benefit, they're no longer going to be able to deduct that as an expense anyway. Another thing that I thought was interesting is this repeals the orphan drug credit. So the orphan drug credit is a credit that pharmaceutical companies get for investigating rare diseases or conditions. So conditions that maybe only several thousand people have, or tens of thousands of people, but certainly not millions of people. So that I thought was kind of an interesting thing to get rid of as well. There's lots of so one thing that I didn't quite appreciate until I read this is there actually are a lot of, whether you want to call them loopholes or something else, there's a lot of provisions in the tax code in terms of tax credits and other such things that are gone, that they are taking out. Here's another one. Prohibition on cash, gift award cards, and other non-tangible personal property as deductible employee achievement awards. So if you're a company and you're giving out $50 Starbucks cards to your employees for doing a great job, that will no longer be deductible.
Seems bad. It seems like this is all just weird. This is not like tax reform. They're just doing whatever they want.
Well, in a way it is, right? So let me defend this as partially as tax reform, right? One of the long complaints, I don't think the process by which they did it is by any means correct. It's definitely wrong. But one of the big complaints of the tax code has always been that there are all of these special deductions that are available, to businesses and to individuals. And so here they are trying to take out a lot of those deductions. So, and there are some that, hurt, kind of traditional Republican constituencies. So, for example, there's a repeal of the enhanced oil recovery tax credit, where you used to get a tax credit for using enhanced oil recovery. And for those that don't know, enhanced oil recovery is when you use CO2, so carbon dioxide, and you pump it down an oil and gas well to get it to produce more oil and gas, even though it's at the it's at the end of its life. Here's another example of something where, no tax exempt bonds for professional stadiums. That's probably a good public policy, right? Why should stadiums have, tax exempt bonds? Doesn't make any sense.
Wait, so the Republicans are repealing the tax exemption for stadium bonds?
They are, yeah.
Oh. Well, I support that. We should do the bill then. Actually, I don't think any city should ever build another stadium, and I kind of think that might be like a high enough policy priority that maybe we should do the rest of the tax bill.
Well, I'm just saying that not absolutely everything in this bill is terrible. Like, I think that on the balance, it's definitely worse. We're definitely better off not doing this bill, but I think we should give them a little bit of credit for taking these things on. You know what I mean? Instead of just saying, hey, let's lower the corporate tax code and then also keep every deduction that's in here. You know what I mean? And
yeah. Well, okay. I have one last question, and then let's do the cake shop case.
Do it, dude.
Do you think that Rubio and Lee would defect? Senators Rubio and Lee would defect from the bill if they don't get what they want on the child tax credit provisions?
Ooh, no. I don't know. I think no, but I hope yes. Here's another thing that I like. This bill gets rid of the new markets tax credit, which I'll explain on another episode as one of the biggest giveaways that there is. Gets rid of that. I think that's good.
All right, you want to do the cake shop case?
Yeah, let's do it, dude. Let's talk about the cake shop case.
This is a case that is before the Supreme Court right now, and it's sort of timely because oral arguments were on. I think the oral argument was on December 6th. So it's pretty recent. But anyway, this is a case in Colorado. There's a store called Masterpiece Cake Shop, and a couple of men, Craig. What are their first names?
Charlie Craig and David Mullins.
That's right. Walked into the cake shop and they said, we would like to have a cake for our wedding. Now, this took place in 2012 when Colorado hadn't legalized same-sex marriage. And so their plan was that they would get married in Massachusetts where same-sex marriage was legal, but they wanted to have their wedding reception. They wanted to have a party in Colorado and they needed a cake for their party. And so the cake shop owner said, no, I'm not going to make a cake. I don't believe in gay marriage and I won't solemnize your marriage with my cake. And so Craig and Mullins filed a complaint with the Colorado Civil Rights Commission. And on summary judgment, the Colorado Civil Rights Commission said, this is not acceptable. That Colorado has a public accommodation statute, and that statute says it is discriminatory practice and unlawful for a person to refuse to an individual or group because of sexual orientation, the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation. And, one form of public accommodation is the retail of things like these cakes. So the Colorado Public Service Commission said, it's a violation of the civil rights statute to deny these folks a cake just because that you don't approve of gay marriage. And so that was appealed to the Colorado Court of Appeals, which is an intermediate level appellate court. And there are basically three arguments that the Colorado Court of Appeals shot down. I'm not going to go into a ton of detail because this is just an overview, and then maybe we can talk about each of them in more detail in a little bit. But the three main arguments were Masterpiece said, we're not discriminating against gay people. We just don't approve of gay marriage. And the Court of Appeal says, well, that's bogus, right? Because, it's conduct that is so inextricably tied to the identity of the people that it's discriminating against people of those identity, even if it's the conduct that you disapprove of. The second thing that Masterpiece said is that the state can't compel expressive conduct, that this cake is, expressive conduct and it's compelled speech in violation of their speech rights to have to make this cake. And the Court of Appeal says, no, that's bogus. And then the third argument was Masterpiece said, oh, well, this is a free exercise clause problem. This is discriminating against us because of our religious beliefs. And the Court of Appeal says, no, this is a generally applicable law. And, it's not a law that targets you or affects you specifically because of your religion. And so that has now been appealed to the U.S. Supreme Court. And the oral arguments were pretty interesting. I think that I think that I don't know. I genuinely don't know how the court's going to rule on this.
What do you think, Tom?
I mean, are we making predictions already?
No.
Is that what we're doing?
No. What do you think about the various arguments?
Well, I think I think AJ is right that it is a very close case. That it is there's sort of arguments on both sides. One thing that I was thinking about just now, as AJ mentioned it, is how does this case interact with the line of RFRA cases from back in the 90s? So,
great question.
For way of background, there was a law back in the day that was sort of a generally applicable law. The peyote cases, right?
Yeah, the peyote cases. Yeah.
AJ, do you guys remember this?
This case is called Oregon Division of Employment, or sometimes people call it just Oregon, against Smith. And in that case, the Supreme Court said that state of Washington can ban, or is it state of Oregon? State of Oregon can ban the use of peyote, and these folks said no. We it's part of our religious practice that we use peyote, and it's important to our religion, and this burdens are the free exercise of our religion. And the Supreme Court said, no, this is a law that's just generally applicable, and we're sorry that it affects your religious practice, but it's a law of general applicability that just happens to interact with your religion, right? And so sort of the counterexample would be sort of a law that banned the wearing of yarmulke is clearly a law that targets Jews, right? Like there's no rational basis for that law except that you're trying to discriminate against Jews. On the other hand, this is just saying, the state has a compelling interest in regulating the use of psychoactive drugs, and we're sorry that this happens to impact the use of your religion, but anyway, so in reaction to that, in reaction to the Oregon case, the federal Congress under Bill Clinton passed what's called RFRA, Religious Freedom Restoration Act. And it basically overturned by statute the Smith holding. It said courts have to apply strict scrutiny to laws that have any impact on a person's exercise of religion, even if it's generally applicable. So take it from there, Tom.
Well, so the interesting part of that is that that case, RFRA, came up before the United States Supreme Court again, and the United States Supreme Court slapped down Congress and said that, look, once we've issued a ruling on what on the constitutionality of a particular thing, Congress can't go back and reinterpret the Constitution, right? Like Congress can't say, well, I think the Supreme Court is wrong about how the Constitution works. In actuality, the way the Supreme Court should analyze these generally applicable laws is if there's an impermissible burden or a strict, under strict scrutiny, basically, right? And so RFRA has sort of existed in this no man's land, basically, since that holding of, only applying to sort of the federal government's own laws, right? Like, so if the federal government passes a generally applicable law, then RFRA can be an exception to that as a statutory matter to that generally applicable law. But it can't be sort of the law of the land as to how all cases are analyzed, right? Or all statutes are analyzed.
So I think that's right. I think that's so right. So in City of Boerne, the Supreme Court said that RFRA cannot be applied to the states. Right. So the part of RFRA that says this is how the court just interprets free exercise claims in general, that was struck down in City of Boerne. And so the federal RFRA doesn't apply at the state level, but the federal RFRA applies at the federal level. Right. So what we saw in the Hobby Lobby case was that there was a generally applicable regulation with regard to the provision of group medical benefits plans. And the Supreme Court said, well, under RFRA, Christian organizations, which somehow includes Hobby Lobby, can't be compelled to violate their religious principles right. And the reason why is because under RFRA, right? So under the Oregon case, under Department of Employment versus Smith, that law would have been upheld, but because of RFRA, that regulation was not upheld. Now, Colorado does not have a RFRA. There's no state RFRA in Colorado, and the federal RFRA doesn't apply to Colorado. And that is why Smith is still good law in this case.
So, so that sort of begs the question: how does Smith impact the court's analysis in this case?
Well, Smith is good law. I mean, Smith is the controlling precedent in this case.
You know, it seems like under Smith, you know, it would lead to one conclusion, but reading the briefs and listening to the argument, it didn't seem like they were giving Smith that much weight.
I don't know if I agree with that. Right? I think that if you look at the oral argument transcript, that Smith sort of features pretty heavily in folks' understanding of the case, right? That this is right. So Smith is only applies to the free exercise clause, right? So Smith says that a law of general applicability that just happens to relate to the exercise of your religion is subject to a rational basis standard, right? Now, there are two key claims that the Cakeshop has. The first is the free exercise clause. Well, it's not the first, but you know what I mean, right? And that, I think, is handled pretty handily by the Smith precedent. The second one is the expressive conduct situation, right? And so Masterpiece is saying that creating this cake for these weddings is speech, and that the government cannot compel speech. So this person says that these cakes are a creative endeavor. It's expressive conduct. It expresses this person's feelings, and so the making of cakes is protected speech, and the Phillips, the person who runs the Masterpiece Cake Shop, has a free speech interest in being able to make or not make cakes as that person chooses. And so Smith is not controlling precedent with respect to the First Amendment.
But that's what I mean. It sure seems like, you're reframing a free exercise challenge in the context of a expressive, a compelled speech challenge.
So I don't think that's right. Right. So I think so let's say the government passed a law that says every shop window has to have a sign out front, and that sign has to say, in Jesus' name we all pray, right? And you would say, oh, okay, well, this is a problem for two reasons, right? First of all, it is a free exercise problem because we don't all pray in Jesus' name. And the second thing you would say is that it's a speech problem because we don't have to put government speech in our shop windows, right? Now, you could imagine the government passing a different law. The government could pass a law that says in everyone's shop windows, we have to put out a sign. You have to put out a sign that says no shirt, no shoes, no service. Well, this wouldn't have a religious impact, right? You wouldn't say that there is a free exercise implication of that sign, although you might say that there's a compelled speech situation, right? So right, it's not that you're just importing one claim into the other claim. I think this is a situation that plausibly impacts both clauses of the First Amendment.
Maybe I don't know. It seems like the rationale and the reasoning of Smith should be a lot more persuasive than it is in this case.
Well, it is. I think if you listen to oral arguments, when the attorneys for on the Masterpiece side are arguing, so the DOJ put someone from the Solicitor General's put someone from the Solicitor General's office up to argue in favor of the Cake Shop, and then the Cake Shop had their own lawyer. And during the oral arguments, there were no questions about free exercise clause. It seems like at least during that half hour of the oral arguments, that the Smith case pretty handily disposes of the free exercise of religion claims.
Mm-hmm. No. What I mean is that the rationale of the free exercise clause, the Smith case should apply or the reasoning should apply in with regard to the compelled speech as well.
I don't think so, right? Because you can have laws of general applicability that compel speech, and that would be a problem even if they're generally applicable, right? So if everybody has a sign in their shop window that says the government is very good, or the war in Vietnam is very good or something, right? Like, that's a problem. That's compelled speech, even though it's a generally applicable law, right? Like, I actually don't think that you should be hands-off in the case of compelled speech just because a law is generally applicable and doesn't target a particular group.
Yeah. Well, but how do you differentiate that type of speech from, say, the type of speech that requires labeling on cigarettes, or the type of speech that requires medical labeling on drugs? Yeah.
So that's a good question, right? So in cases of compelled speech, there's a high standard that the government has to bear, right? They have to show a compelling interest, and it's not strict scrutiny, right? But they have to show some sort of high level of relationship between the government law and the interests that the government is seeking to enforce, right? And so I think that there's a genuine interest in having accurate labeling on cigarettes or other products, right? And so I don't think you would say that that's necessarily a problem.
Mm-hmm.
So one of the things that's interesting to me about this case is, and this is not unique, I guess, but it's sort of a where do you draw the line on these things, right? Which is, could this guy say, listen, I don't believe in, I mean, I assume he would argue I don't believe in interracial marriage, and so I shouldn't have to put anything on a cake for an interracial couple if I don't so choose.
So there's Supreme Court precedent on this. There's Supreme Court precedent on this exact question. It's called the Bob Jones University case, and in that case, Bob Jones University had dorms specifically for married students. Right, it was like family housing for married students, and they said interracial couples can't use our dorms. And what the Supreme Court said is no, like that's discrimination against Black people. And Bob Jones University said, no, it's not. You know, we're not discriminating against Black people. We're discriminating against a certain type of conduct. That conduct being when Black people marry white people. And what the Supreme Court said is no. Right, that kind of conduct is so inextricably tied to that person's identity. Right, it is an inherent feature of their identity that what the university is doing is discriminating against Black people. And so I think the answer there is that the Supreme Court has already directly addressed what it means when you discriminate against people on the basis of their interracial marriage.
Yeah, but what the Cakeshop, what the argument from the Cakeshop folks was that if there was a case where you had an objection to, for example, interreligious marriage, they could not bake a cake for an interreligious couple if they wanted under the compelled speech doctrine. So it seems to me that, you have on one hand, racial classifications being set aside as, okay, they have to make a cake for an interracial couple. But the very next question that Justice Kagan asked is, well, what if, he objected to an interreligious couple? And the petitioner says, well, yeah, it would be a similar case to this case, and that would be protected under the compelled speech doctrine if the objection to the message is being conveyed in that expression.
I mean, I think the petitioner is wrong. I think petitioner was wrong in saying the thing you just said. I think petitioner is wrong in petitioning in the first place, right? Like the Cakeshop is right. Like, I think you're right. I mean, I think that's like a serious implication of the case, but I think the answer there is very easy, right? I mean, the answer there is that when you pursue a course of action that discriminates against people because of the nature of their marriage, because of who participates in their marriage, right? Whether it's because the marriage is between two people of different races, or it's because the two people are of the same sex, right? Like, that is a clear case of discrimination under the Colorado statute.
Yeah. So, but how do you draw that line? You know what I mean? I don't see how you can. It's a difficult argument to get around that to endorse the Cakeshop's position would necessarily mean they can also, what differentiation can you make between a Cakeshop discriminating against gay people versus a religious couple?
I don't know why you would want to distinguish that.
Well, I think the Supreme Court would have to in order to find for the Cakeshop.
Well, Tom's trying to analyze it, right? So let me say, so I'm trying to say, okay, let's say that you believe that this guy's so it seems like this particular baker's religious views are sincerely felt, number one. Number two, he seems to earnestly have a problem with baking a cake for a gay couple. Number three, I think we do agree that making a cake is expressive conduct, right? Can we all agree on that?
No, we don't agree with that.
Oh, we don't agree with that. Okay.
We don't agree on that. So if baking a cake is expressive conduct, then Colorado loses.
Hold on, AJ. Hold on a second. So let's say that baking a cake is, just for the sake of argument, let's say it's it is expressive conduct, okay? At that point, you cannot open the door to allowing him to discriminate against a gay couple, but close the door on allowing him to discriminate against an interracial couple or an interreligious couple or any other couple, right?
Yeah.
And I think that's sort of, I think that's sort of the discussion is this can't, the problem and the problem by this, I mean, not just the moral problem, but let's call it the maybe even political problem, is you can't, it cannot stop. If you allow him to discriminate against a gay baker, or not a gay baker, but a gay couple, then you have to allow him to also discriminate against a interracial couple or a interreligious couple.
Yeah.
Do we agree on that? Like, there's no, I can't think of a way to sort of distinguish the situation of a gay couple versus an interracial couple.
Yeah, I think that's right.
I mean, the court could say that gay people are not of the same status as religion and race.
But the Colorado statute specifically extends their public accommodation law to protect people based on their sexual orientation. Right? Like it is in the text of the statute that places of public accommodation can't discriminate on the basis of sexual orientation. So what?
Like that has no effect on what the Supreme Court could do, right? Like what I don't see the relevance to, or I don't see why that's important or affects why the Supreme Court couldn't just differentiate between gay people and religious people, just draw a line there. I'm not saying it's good. You know, in the same, hold on, let me give you an analogy. In the same way that the Supreme Court has held that gender discrimination deserves only intermediate scrutiny, right, versus racial discrimination or discrimination based on religion getting strict scrutiny, right? Like in effect, what they're saying is, like if you're discriminating based on the basis of gender, we're not going to scrutinize that law as much as if we're discriminating on the basis of race.
So here's the answer to your question, right? The Supreme Court is only going to rule on the federal law claims in the case, right? And so the federal law claim in the case is that the Colorado statute says you can't discriminate in public accommodations on the basis of sexual orientation. And this cake shop said, I'm not going to make a cake for a gay wedding. And the Colorado Civil Rights Commission said, you have to make cakes for gay weddings, right? So that's where we're at, right? The Supreme Court has two federal law claims before it. The first is that requiring someone to make cakes for gay weddings compels expressive conduct, right? That there's a particular type of speech that happens when you make a cake for a wedding, and that the state can't force you to engage in that speech conduct unless you want to do it, right? And right, so the principle here is not, the state can force you to engage in speech conduct for religious weddings, for interfaith weddings or interracial marriage, but the state can't force you to engage in speech conduct with respect to same-sex marriages, right? Like that is not a cut that is available in this case, right? So the cut that the Supreme Court is angling towards is that cake making is expressive conduct, which means the state can't burden your cake making conduct in any way, or cake making is not expressive conduct, in which case the state can make you bake cakes for any sort of wedding.
So AJ, your position is that the procedural posture doesn't allow the court to address it, but to say that the court isn't going to address the next implication of a rule they set out, I think is far fetched. I mean, the Supreme Court has to address the implications of the rules they set out. Otherwise, it wouldn't be a well-reasoned opinion.
Yeah, they're not the Trump administration.
I mean, so I think one of the things that Breyer says in the oral argument is that there's no way to make this cut, right? If you make this cut, then public accommodation laws no longer protect black people or religious people or whatever, right? There's no way to make this cut without tearing apart the entire framework of public accommodations laws. And so I'm sort of curious, like, how you think the court would navigate that.
Well, I mean, the just because Breyer says it doesn't mean it's going to be a 5. He's got the 5 votes to say that, right? Like I can see a conservative majority of this court simply go and carve out gay people from the protected classes that public accommodation laws would can effectively prevent discrimination against.
Like how would they word that?
Using words? I don't understand your question.
So what the court would have to do, I mean, so let's say they say, so first of all, if cake baking is not expressive conduct, then we're done, right? Because there's no freedom of speech claim, right? So first the court would have to say that making cakes is expressive conduct, right? And then they would have to apply some sort of balancing test, right? They'd have to say, oh, like does the state have some sort of compelling interest, and is the law appropriately tailored to that compelling interest, right? And so like which of those two prongs do you think, right? Are they going to say that preventing discrimination against same-sex couples is not a compelling interest, or do you think that they would say that public accommodation laws are not tailored to that compelling interest?
Yeah, I think either of those could be a way to differentiate if they wanted to from religion and race.
So protecting, I don't think you can get 5 votes for saying that protecting discrimination against gay people is not a compelling interest. I don't think there are 5 votes for that, because otherwise, how could you have had the Obergefell decision, right? Like the Obergefell decision recognizes the inherent dignity of these people, and like Kennedy's decision is like very serious about talking about the slights that the government, the slights and the serious affront to the dignity of human beings when the state denies them the freedom to love whom they want to love, right? And so I don't think that you could get 5 votes for the court to say that the state has no interest in protecting people from discrimination based on their sexual orientation, right? So that's out. So then you would have to talk about some sort of tailoring thing. But if you have to admit that protecting gay people from discrimination is of a similar government interest to protecting people from discrimination based on national origin or their race or ethnicity, right?
Why do you have to admit that?
So what you would say is that public accommodation laws are appropriately tailored to the interest in protecting black people from discrimination, but not with respect to gay people?
Yeah, but I mean, why not? Why couldn't they say that?
I just don't. I mean, I don't think that you could do that with any sort of like sincerity, right? You would have to. It would be so obvious that they're. It would be so obvious that they just don't like gay people.
And remember, like, they don't have to use that for, like, we have this framework, but that's what's so crazy about constitutional law is they don't have to use that framework if they don't want to. They can dress it up in a different framework. They can create a whole new framework for when these types of laws are in conflict with a protected class, for example.
So who's the 5th vote? Who's the 5th vote for the
Kennedy?
You would think Kennedy.
Yeah, all that matters here is what Kennedy thinks, right?
You would think Kennedy would say that gay marriage is the law of the land, but also that public accommodation laws can't protect people based on sexual orientation.
I think it'll be a little bit more nuanced than that, but yeah, I think you could get. In fact, that I'll give you guys my prediction first. I think it's going to be 5-4 for the cake shop.
And what's Kennedy's reasoning going to be, Tom?
I think it's going to be something a little bit wishy-washy, sort of like,
Kennedy? Wishy-washy?
Yeah. 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 It's going to be something sort of we have competing interests, balancing, and we need to balance these competing interests. It's important, that gay people don't, aren't stigmatized, and all of the flowery language that he used in Obergefell, and then he's going to turn around and say, at the same time, it's important that sincerely held religious beliefs are protected, and we don't let them do blah 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 blah. We don't force them to take conduct that they don't want to take. At the end of the day, I think what he's going to do is he's going to try to craft a more narrow understanding of what is expressive conduct. In deciding this case. That would be my prediction. What are your predictions?
I really don't think that that's likely to happen. I mean, I guess it's possible, and I genuinely don't know what the outcome will be, but I think the odds that Justice Kennedy says that that states are not able, right? Like the great laboratories of democracy are not able to adopt public accommodation laws that protect people based on sexual orientation in the same way that they protect people based on their race or national origin. I think is an unworkable distinction, right? So the Supreme Court has already directly addressed religious claims about discriminating against people based on race, right? So like the Bob Jones University case, for example, right? Like religious arguments that underpin objections to public accommodation laws or non-discrimination laws, religious arguments have been rejected by the court, right? There is no religious interest in discriminating against people based on race. And so to say that there's this sort of compelling religious interest in discriminating against same-sex couples, but you can't discriminate against race for those same reasons, I think is an unworkable standard. And I just don't see Kennedy going for that. I mean, it could happen. And I guess, I would be a little surprised, but not very surprised, but I still don't think that that's the most likely outcome.
So you think 5-4 Colorado or a different vote for Colorado?
I kind of think it might be 6-3 Colorado.
6-3 Colorado?
Wow.
Who do you think is
Roberts?
Roberts?
Oh, interesting. So I think I've been reading through this transcript while you guys have been talking and listening to, obviously, but there's a portion in this transcript where I think Kagan kind of gets it on the mark in terms of what this case is really about, and I think what people are sort of struggling with. So she talks about it in terms of 3 axes. The first axis is, how do we draw the line on whether this is expressive conduct or not? And so, there's a lot of discussion in the oral argument about, so the baker, if you think the baker is expressive conduct, what about the florist? What about the person that writes the invitations? What about
this was
the
a
chef?
really interesting passage.
It's a really interesting passage, right? Because everyone can, I think you can say, listen, what I do is expressive as well, right? If the cake baker is doing something expressive, why isn't the florist? Why isn't the person that's dressing the bride? Why isn't the wedding planner? Why isn't everyone that's an artist engaging in expressive speech? So that's the first axis. The second axis is, why is it only about gay people? If it is expressive speech, why can't that person then also discriminate based on gender? Why can't that person also discriminate based on religions, and so on and so forth? And then Kagan says there's a third axis, which is, why is it just about weddings? What about ceremonies? What about events? What if there's a funeral and someone says, well, I can't do something for a gay person that died? What about a bar mitzvah? What about an anniversary celebration? What about and then she gives the example of an anniversary dinner that a gay couple is having at a restaurant, and they're going where there's this great chef, and the chef says, listen, I just don't, all of my food is expression, and I just can't express those beliefs for a gay couple. You can't compel me to sort of make you a meal.
Well, I thought it was fascinating when the lawyer for the cake shop said that a chef making a dish is not expressive conduct, but a baker baking a cake is expressive conduct.
Mm-hmm.
Yeah. I think the cleanest place for the court to end this is to just say this is an expressive conduct, right? Is to just say, listen, you're baking a cake, and the purpose of the cake is to be eaten, and it's pretty as well, but those are not your views, because at the end of the day, you put, you're for hire. You're like anybody else that's for hire, which is to say that, you put a message on a cake, and, you're not expressing yourself so much as helping the couple express themselves. Do you know what I mean?
I mean, I can't remember who said it during oral arguments, but someone said, if you go and get cupcakes for someone's birthday, right? And the cupcakes say on them, happy birthday, John, right? No one thinks that the baker is wishing John a happy birthday, right? They think I'm wishing John a happy birthday because I brought the cupcakes.
Yeah. Yeah. I mean, I think that's a good point too. So, I struggle with this one a lot, right? And so the lawyers for the government talk about, well, could you force a could the Ku Klux Klan, he says an argument something like this, which he says that we don't believe that a Klan member can force a an African American baker to make him a cake, and I struggle.
Yeah, but that doesn't apply because being a Klan member isn't a protected class. That's an easy differentiation.
And I think there was one of the justices during arguments. I think it was Gorsuch. Gorsuch was awful during oral arguments, by the way. But Gorsuch also brought up sort of like the KKK example, right? Well, do you have to make cakes for the KKK? And the idea that like gay couples are somehow comparable to the KKK, right? That objections to the KKK are of the same nature of objections to same-sex marriage, I think is totally offensive, right? I think it was insensitive and offensive for Gorsuch to entertain that line of argument.
What do you think about one of the questions that was asked is, well, hold on, before we go, Ruchit, do you have a prediction?
Yeah, I have a prediction.
Before we move on,
yeah,
what's your prediction?
I have a prediction. My prediction is it's going to be 5-4, and I think I agree with you, Tom. I think it's actually, I'm going to go on the flip side of you. It's going to be 5-4. Kennedy's going to write the majority opinion, and it's going to be somewhat incomprehensible, and it's not actually going to settle this issue.
5-4 for the cake shop?
Yeah, no, I think it's going to be 5-4 for Colorado.
5-4 for Colorado. I think it's going to be 6-3 for Colorado, and Tom thinks it's going to be 5-4 for the cake shop.
4 for cake shop, yeah. So what do you think about the question? Can an opera singer be forced to sing at Westboro Baptist Church, which was one of the questions that came up during oral argument?
So I don't think that an opera singer is a public accommodation.
Well, what if it's like an 80s cover band, right? Like, what if it's something that's like, an 80s cover band or a clown?
So an important here is Colorado's definition of a public accommodation, right? A public accommodation is providing goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation, or directly or indirectly to publish, circulate, issue, display, post, or mail any written, electronic, or printed communication, notice, or advertisement that indicates that the full and equal enjoyment of the goods, service, facilities, privileges, advantages, or accommodations of a place of public accommodation will be refused, right? So if it's a place of public accommodation, right, it's the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation, right, that have to, right, like public accommodations have to be provided on a non-discriminatory basis, right? And advertisements for public accommodations have to be provided on non-discriminatory basis, right? And so it's not clear to me how someone traveling to a private event at the Westboro Baptist Church is a public accommodation, right? Now there actually is a New Mexico case called Elaine, and in the New Mexico case, the New Mexico public accommodations law said was held by the New Mexico Supreme Court to say that a photographer has to travel to your wedding and perform the wedding photography at your wedding. At the very least, a wedding photographer can't discriminate against you based on whether you're a same-sex couple or not, right? And so I think maybe there are other cases that implicate that, but I think the first answer there is that this is not a case where you need to decide that, right? You don't need to decide whether an opera singer has to go perform at the Westboro Baptist Church. And
I never like those arguments or that response. And when listening to oral arguments,
yeah.
when a party says you don't have to decide that here, it's almost silly to think that, well, what should I do with that thought, right? Like, because that the implications of the rule that you're setting down has to be thought through, even if you don't decide the next case today, you still need to think, okay, how is this rule going to affect the next case?
I think the second answer is that it's much more likely that opera singing is expressive conduct than cake baking. Right? Like I don't need to be able to tell you exactly where the line is between expressive and non-expressive conduct, but I think it's far easier to imagine why opera singing is expressive. And then finally the answer is that maybe an opera singer has to go perform at the Westboro Baptist Church. Like I'm not sure why that is such a negative result.
Yeah, I think that's something that nobody's really been willing to sort of say, at least as far as I've seen, other than you, AJ, right?
Well, I think one of the lawyers in the oral argument transcript said that. I mean, so yeah, I mean, there is an example in oral argument. I think Chief Justice Roberts said, what about Catholic Legal Services? What if Catholic Legal Services says that we don't want to So Catholic Legal Services is a nonprofit. They have sort of an office location where anyone in the public can just walk in and get pro bono legal services, and they do all sorts of stuff. I think most of what they do is immigration, but let's say that there's an office that helps people with wills, and let's say that there's the organization says we're a Catholic organization, we don't support same-sex marriage, and we're not going to help you do wills if you're in a same-sex marriage. So we're not going to help you devise your estate to your same-sex partner. Does Catholic Legal Services have to do that? And what the lawyer for the respondent side said is, it is very possible that Catholic Legal Services has to do that. It's very possible that if this is sort of a retail service that Catholic Legal Services does for anyone who happens to walk in off the street on a retail basis, that this is a retail public accommodation that they would provide to anybody who walks in off the street except for same-sex couples, then that's discriminatory, and it's not the kind of discrimination that we should have in our country. There's a line in the Smith case, and the gist of it is basically that if you were to, no matter how sincerely held your religious belief, right? If you were to allow people to carve themselves exceptions to generally applicable laws based on their religious beliefs, then every man would become a law unto himself, right? Anybody who happens to have a sincere religious belief could choose any law whatsoever and just not have to follow it. And it is untenable in a society, in a communal society where people have to live and work together, to let each person become an island with respect to the law just because of whatever beliefs they may happen to hold. It's not clear to me why it's such a terrible result that Catholic Legal Services has to probate wills for same-sex couples.
Do you guys want to play a game?
Yeah.
I want to talk about one thing real quickly.
What?
Gorsuch is terrible. Gorsuch, I think, is the only justice throughout the oral argument transcripts who really does not acquit himself well. He has this sort of offensive comparison between.
He's just a general. Yeah. He just doesn't he thinks. I get the feeling that he thinks everything is a rhetorical game. He's like a right wing or left wing college student. You know what I mean? That just thinks everything is a game, that these aren't real people's lives, that these aren't real issues. It's all just a game about who can make a more clever argument. And so let me go and make a clever argument that may be a gotcha, you know what I mean? But probably isn't, because it's not actually an accurate recitation of the facts or the law. That's his approach. It's his approach.
So one of the commissioners on the Colorado Civil Rights Commission said during deliberations that commissioner thinks it's despicable when someone hides behind their religion in discriminating against others. And the lawyer for respondents said, that is not, if I were his lawyer, I would not have advised him to say that in public. But there are 7 commissioners on the commission, and do I think that this shows some sort of hostility to religion on behalf of the government? And the answer is no. This statement alone is not an example of the government's hostility to religion or whatever. And Gorsuch latches onto that statement. He's like, oh, this commissioner is biased against religion, and all of their deliberations. When you have a 3-judge panel, if one of the judges is biased, then the whole panel is tainted because it's a deliberative and collaborative process and blah blah blah. And Gorsuch really seems to be digging into this. I mean, it's basically I think there are only 2 possibilities here. One, it's insincere and Ruchit's right.
I think he's forgotten that he's not a litigant.
Right? One, I think Ruchit's right, that it's just a rhetorical game and he's accusing these commissioners of bias. Or he really, is high on his own supply. And I can't tell which one is a sadder thing to say. Anyway, Tom, that was the other thing I wanted to say about the case. So what's the game you wanted to play?
Okay, so I looked at the all of the amicus briefs that were filed in this case, and I'm going to name you a group that filed the amicus brief, and you guys guess what side they support. Okay,
this is a good game. This is a good game.
All right, so I'll
AJ,
start
this
off
needs
easy.
to make the show, AJ. I don't want to hear any of this bullshit about this can't make the show. It's off our brand. Or Dom, do you have other things that AJ might say that would justify him trying to cut this shit?
I mean, he might just insert another hour conversation about taxes in its place,
dude. Okay, Tom, this game is great. Let's hit it.
Okay. All right. So I'm going to start off easy. And this one you should be able to guess this one. Ken Paxton on behalf of the state of Texas.
He's on the side of the baker, no doubt.
He's on the side of the baker.
Yeah, he's He believes that cakes are artistic works created by unique snowflakes and are entitled to freedom of expression protections.
Did he really say
no
unique snowflakes?
No, he didn't actually say unique snowflakes, but he did. But that was the argument that he was making, is that cakes. He was heavy on the cakes are artistic works, and are entitled to freedom of expression. I added the unique snowflakes part. All right. So next, American Psychological Association filed an amicus brief. Who did they support? The cake baker or the gay couple?
Why does the American Psychological Association file a brief?
Well, and here's another aspect to this game. You can predict who they supported. Obviously, don't look it up and cheat.
That would be wrong.
You can guess who they supported and why they supported it, or what argument they were making.
This is a really fun game. This should be the beginning of the show.
So, American Psychological Association, who did they support?
They supported the gay couple, or Colorado, I guess. And the reason that they did this was on the grounds. They probably talked about the huge psychological harm that when you were denied services that anybody else can go and get.
I have a guess.
What's your guess, AJ?
My guess is that the psychologists are arguably a public accommodation, and they want the narrowest possible applicability of public accommodation laws, and they support the cake shop.
Oh, that is clever, AJ.
Yeah. That's good, but Ruchit is right. They supported Colorado because their entire brief centered around the fact that being gay is not generally thought of as a choice, and that gay people face significant stigma in society, which can lead to psychological harm. Okay, next one. American Academy of Pediatrics.
Oh, that one's easy, dude. That one's easy.
What is? Yeah,
yeah. They're gonna be for Colorado, and they're gonna talk about the just sort of what how much of a how much harm it can cause the children of gay couples, for example, if their parents are constantly being discriminated against.
AJ,
I'm gonna guess my same one again. That it's a public accommodation and blah blah blah.
AJ might be right someday.
Well, AJ is right, but not for that reason.
What?
Yeah. So the American Academy of Pediatrics is not the sorry, hold on. Sorry, I should have said American College of Pediatrics. But basically they're this conservative group of pediatricians who paired up with the American Association of Pro-Life Obstetricians and Gynecologists and the Christian Medical and Dental Association.
I'm disgusted.
And they argue that the court should the court find for the gay couple, these groups might be forced to counsel their patients about the availability of abortions.
Oh.
So they don't want to do that, and so they support the cake shop.
That's all
right.
Sad.
Now I'm going to name you some individual people who are amicus, right? So these are individuals who filed an amicus brief on their own sort of behalf, if you will. Aaron and Melissa Klein, a couple from Oregon.
They're going to be on the side of... well, hold on. Maybe, actually, this probably would give it away. Is it Aaron with an E or Aaron with an A?
Aaron with an A.
Oh, then it doesn't give it away. If it was Aaron with an E, I assume they would have been on the side of,
Aaron and Melissa Klein.
Mm-hmm.
I think that they own a small business and they don't want to be subject to public accommodation laws.
Ooh, that's a good guess.
By the way, that's going to be my guess for every amicus. Every amicus, I'm just going to assume that they offer public accommodations and they don't want to have to obey the law.
Okay. What do you think, Ruch?
I think they're in favor of Colorado, and honestly, they're just two lawyers, that just wanted to make a difference.
AJ's right. AJ's right. Aaron and Melissa Klein were the proprietors of Sweet Cakes by Melissa, which, if you remember, made some news because the state of Oregon fined them for not creating a cake in Oregon for a gay couple that wanted a cake for their wedding. So basically, this is like their case is pending in the Colorado appellate courts right now.
Oh,
Oregon.
So that's their interest.
Oregon appellate courts, probably.
All right, wait.
All
I want to do one. Are you ready? This is one I noticed.
Wait, I've got 3 more.
Oh, I want to do one though. Rich and Tom, guess. Cato, CATO, the Cato Institute.
Oh, come on.
They filed an amicus?
Yep.
Yeah.
They
filed it in favor of the cake shop.
I'm going to go with Colorado. They filed it in favor of Colorado.
No, Cato filed in favor of the cake shop.
Yeah, but that was right.
All right, let me give you a couple. Let me finish my list. All right. You're gonna like. All right, so David Boyle, he's a lone lawyer from Florida.
Is he like by lone? Do you mean he's alone, or like is he not married, or
David Boyle filed this brief on his own behalf by himself. So he is both the attorney of record on the brief and he is the amicus curiae.
Tom, I have a guess.
Yeah?
He is worried that his law firm is a public accommodation. And he doesn't want to be subject to the law.
No. Ruch?
I think he just, he's just all about fairness. You know what I mean? And so as a result, he's supporting Colorado. He used to live in Colorado.
Okay, well, neither of you are right because this is a trick question. He supports neither party.
Why
he
did
thinks that there should be a...
What the hell? Why did he file an amicus?
Okay, another lone lawyer.
Hold on. So what does he think? What does he think? Hold on.
Oh, he supports neither party and thinks there should be a narrow holding. The peculiarities of his brief are not too relevant. I just thought it was funny.
Tom.
Okay. One more. Richard Lawrence, another lone lawyer.
Dude, who are these people?
He filed in favor of the couple. He filed in favor of Colorado.
Okay, Ruch.
He filed in favor of Colorado.
Okay, the reason I didn't tell you where he was from is because I think it would have given it away. He's from Alabama. He's been married for 47 years to the same woman, and he believes that marriage is between a man and a woman. All right, one more. This is the last one, okay? National Black Religious Broadcasters.
Oh, dude, this is definitely they're there for the bakers, dude. They're there for the bakers.
They're there for the bakers. They're worried that their broadcasting is a public accommodation.
Yeah, no, they don't. They're worried that marriage is between one man and one woman, so they're supporting the bakers. But that's it. That's the game. Good job, guys. That was a lot of fun.
That was fun. We should do that again. That's fun, Tom. I like this game.
Ruch, what's your sidebar?
Dude.
One of my great joys is asking Ruch what his sidebar is and then him just saying dude. Because each week he hasn't prepared one.
Dude, that's not true.
How hard is it, dude? How hard is it when you're doing your normal sort of reading and perusing newspapers to see something interesting and then just make a note?
Dude, because here's the thing. I don't read a lot of interesting things that are not political or historical or something like that,
But those would make great sidebars.
No, I don't read a lot of those. Is what I'm saying.
What I'm saying is you're a great historical story that's entertaining and fun. It could be a sidebar.
Oh, okay. Well, when you think of it that way. Okay. Here, let me talk my own book. Okay. Let me talk my own book. So I recently bought some. So we've had a few previous episodes on Bitcoin, for example. So I recently bought some Litecoin, which is a Bitcoin competitor currency. It's one of the
God, the
top
SEC
5.
Ruch, are you hawking another product?
The SEC is going to shut down. You can't buy a security and then promote that security right away.
It's not a security. It's considered a commodity, dude. It's regulated as a commodity.
No, there's a court. The courts have differed on whether cryptocurrency is.
No, it's not. It's they're not even regulating it as a currency. They're regulating it as a commodity.
No, courts have split on that.
I don't think this shit is so new. I don't think courts have really reached this issue yet, have they?
No, courts have split on because there was a federal court in Texas, and the question was if there was a website that was providing services with respect to Bitcoin. I think it was some sort of coin wallet, and they were being prosecuted for fraud under the Securities and Exchange rules. And basically, if Bitcoin were a currency, right, then securities or interests that are denominated in a currency, right, are subject to the Securities and Exchange Commission rules. And so, if Bitcoin is a currency, anyway, there's one court that said that Bitcoin is a currency and the SEC laws apply, and there's one that said it's not or something. There's like a court split on this.
Well, in any event, I own some Litecoin, so the price has gone up a lot in the last.
Rich, I can't put this in the show because we'll all go to prison.
No, we won't, dude. I own some Litecoin. I can't state the fact that I own some Litecoin?
No, because it's for the dark web. You're using it for drugs.
No, I'm not. I'm using it purely for speculative purposes in the hopes that its value goes up.
Yeah, it's drugs. It's value denominated in drugs.
No, it's not, dude.
I think we need to have a new rule for the show, and that rule is Ruchit cannot hawk things that he has a financial interest in.
I've never hawked anything that I have a financial interest in until now.
Dude, coolest cooler.
Dude,
coolest
I don't have
cooler.
financial interest in that.
Yes, you do. The only way you're getting that cooler is if other people buy it.
I never promote that cooler. You idiots are the ones that keep talking about it. You keep hawking the coolest cooler. No one should buy the coolest cooler. It's a scam. I can't make it more clear. Do not trust Ryan, whatever his name is.
Hey, so can I ask you a serious question? Hold on. Can I ask you a serious question about cryptocurrency?
Yeah, dude.
All right. So you are obviously an environmentalist. Like, how does your environmental values score with the fact that Bitcoin is horrible for the environment?
That's a great question, Tom. So honestly, I don't know. And I own very little Bitcoin. I'm really doing this mostly as an experiment. So I own very little Bitcoin. I own no matter what you call it, I own very little Litecoin. I own very little Ethereum. So that's a serious moral issue, dude. That's a serious moral issue.
Here's my sidebar.
No, I mean, no.
My sidebar,
this is a good conversation.
My sidebar is
AJ doesn't want to explore this any further.
Why not,
sidebar
dude?
is the National Association of Attorney Generals. Their director and chief counsel, Dan Schweitzer, put out a U.S. Supreme Court brief writing style guide. This is from the summer of 2017, so this is still current, sort of. But it's like interesting. It's like if you're like interested in like typography or in sort of like layout or design or typesetting, if there's anything that you're like slightly interested in, and particularly if you're slightly interested in legal writing, then this is like kind of interesting. It's all full of like little details, right? Like, should you underline or italicize case names? For example.
What did they say?
What he says is that you should italicize case names, although there are a small number of courts that expect you to do underlines. Also, here's something interesting. There actually is a split on the bench, like in the Supreme Court, about whether citations should go in footnotes or be inline. I think that's like an interesting question. Like, should you put your citations in footnotes or not?
I think they should be inline, man. I'm a believer in inline. I don't think it should go down to the footnotes.
So here's what I think. At the Supreme Court, at the level of the Supreme Court, you should expect people's citations to be good, right? Like,
at the Supreme Court. Okay, never mind. I missed that part. Yeah, I agree.
I mean, this is the Supreme Court style guide, right? Like, you should expect people's citations to be like. So the reason why you would put citations in line is so that you don't have to like scan your eyes up and down to the bottom of the page. To know like the weight of the authority that supports a proposition. But I actually think it's like sort of safe to assume that like propositions in Supreme Court briefs are like well supported, right? Like like the footnotes.
Yeah, unless it's Gorsuch that put the proposition out.
Yeah, but I mean, like, you know what I mean? Like, I understand like the value in having the citations in line so that you can see like how good is the support for the proposition, right? Like, what are they citing? Are they just citing like some random law review article, or are they citing a good case or not, or whatever? But I sort of think that like at Supreme Court advocacy, like the proposition should be well supported. Like, you don't need to check. I mean, you should check eventually, but I just don't think you should check like every time you're reading. You should have to scan past like huge string sites or whatever. You know what I mean?
Yeah.
Anyway, this is like an interesting document. Here's a paragraph in the style guide. Are you ready? The conclusion in a Supreme Court brief should do no more than state the relief being sought. That can usually be done in one sentence. Quote, the petition for a writ of certiorari should be granted. If you want to add, for the foregoing reasons, that's fine.
I like my sidebar a lot better than AJ's, I have to say.
Litecoin?
Yeah, dude.
I'll give you my sidebar, and I'll link it into it's in the show notes, but I'll put it in the Slack as well. This is a Seattle Times article, and what happened is that Seattle Times, these folks are investigating a crime that occurred, right? Actually a Texas slaying, and they have DNA from the killer, and they use the DNA to create a snapshot prediction of what they think an individual looked like. Now, they have no eyewitnesses, nothing like that, right? But they're able to use DNA to establish, okay, this guy is a male, this guy's age is unknown, body mass unknown, but he's got Northern European ancestry, and then just look at the image in here, right? Like they're able to kind of predict his skin color, his eye color, his
face,
hair
too.
color, his freckles, that sort of thing. Give sort of like a what they call a phenotype report, and using this sort of prediction from the DNA, they're able to track down an individual, and it led to a confession.
This is some like Minority Report stuff, dude.
Yeah, it's like next level crazy,
This is ridiculous. But there's so it looks like they just they did some sort of they did a sketch of what they thought the person looked like without, right?
Yeah.
Like there's an actual it says snapshot prediction results, and it's a picture of a white dude with some dirty blonde hair, and they're like, oh, this is we have a relatively high degree of certainty just from the DNA sample that the person sort of looks roughly like this.
Yeah. But in actuality, what they're doing is they're able to predict certain types of things, right? Like, male or female, what region of the world his ancestry is from, skin color, eye color.
Yeah, but they can't actually tell you his face, right? They can't tell you what he looks like, but yet they've drawn out what they think he looks like. But what's the science behind?
Not yet, dude. Not yet. Oh. Not yet.
Oh my God, this is nuts.
The percentage of like freckles, for example. Like, what are the confidence that he's got freckles?
Yeah, but that doesn't tell you whether you. I mean, it's just what does this guy actually look like, right? I mean,
well, hair color, eye color, and skin color are pretty important characteristics, right?
Yeah, but I mean, you could describe a lot of people that look like me or you, Tom, right? Probably, hundreds of millions for me, and probably the same for you, right? In terms of hair color.
But it's just kind of nuts, that. Yeah, that's what sidebars are for.
So we didn't go to Warby Parker last weekend because I was sick.
We're going, right?
And this weekend we're really going to do it. We're really going to go to Warby Parker. Should we go now? Tom, you want to go now?
Yeah, let's do it.
Probably not.
Dude, why not?
You guys go without me.
Ugh.
Is this one of those you live in a small town in Texas things and you just can't be bothered or something, or?